Good morning, everybody. Today we'll be talking about a few aspects relating to negotiable instruments. So I'll try to cover this in about two sessions. So I have a presentation which I will go through, but apart from that, there will be a few other things that I'll be talking about. So first, why do you need negotiable instruments? The negotiable instruments are nothing but they are equivalents of money. If you have money for transactions, you are issuing that and you will be in a position to get your financial transactions through. But in case you can't use money or you don't want to use money, in those kind of cases, you will try to use the negotiable instruments because it will provide you with the option to have international transactions also, to have movement of money from one place to another, to use intermediaries for the purpose of transactions, and finally, it is an easier mechanism of delivering money. So from those points of view, negotiable instruments are important. So the moment you have a lot of trade, you need to have a financial system which is capable of providing you with those instruments through which you can make payments for the trades to happen. So if you have the transaction now and it is completed now, cash is the best way of transacting. But if you are not in a position to physically give cash, or if you are not in a position to pay now, or if you want the money to be paid to someone else, these are the cases where you will have to, your transactions are facilitated by having negotiable instruments. So this is the very perfunctory kind of gist about a very basic level of gist as far as a negotiable instrument is concerned. So basically, it is a mechanism of payment, mechanism for payment of money. So as I told you, if you want to pay cash, you pay cash now. But if you want to have a payment at a later date, so maybe you are moving goods from one place to another, foreign transaction you are doing, or you are selling your rice to a different place. So you want to make payment to that person. You want to receive payment from that person, or you want to make payment to that person there. So you may have to after a later date of a point of time. So you may have to execute a contract saying that I have availed of these services. In consideration of these services, I am paying you the money on this particular, I'll pay you the money on this particular day. So it will be a contract and the enforcement of contract will be very difficult. Suppose he wants money now, he will have to assign this contract to someone else, and the person who is receiving this contract, he is not very sure about whether he is actually going to receive money or not. So the trust between these two parties, whether this party will entertain and fulfill the obligations under contract, all these things will make the legal process very complicated. And the moment you are having a legal process which gets complicated, the ease of transactions will be hampered. And to facilitate this ease of transactions, the innovation is coming out in terms of having a different kind of instrument which is similar to money, which can be used for financial transactions. So a contract makes it cumbersome. A negotiable instrument also technically is a contract only, but it is a special contract which is recognized through through the law called Negotiable Instruments Act, and the documents have been given the status as legally recognized written documents. The advantage of negotiable instruments are that they are easy to make. Second, they are easy to transfer, and they are convenient to the parties. And because of all these things, it is very easy to use them for financial transactions. So, what is the common parlance that is there in relation to negotiable instrument is? It is a written document. Always a negotiable instrument is a written document which entitles a person. So this document is an entitlement of a person to receive a certain sum of money. So it is not a ambiguous amount that is there, but it's a particular amount of money. And this instrument or this document is freely transferable from one person to another. So that I am supposed to be receiving money. Someone is prepared to give me money. So I will transfer it to him and receive money. And the other person will now receive the money from the person who is originally supposed to pay. So in this way, it is easily transferable, and the transfer could be by endorsement, and delivery or by delivery. We will deal with it subsequently. Delivery is basically a bearer instrument. You merely deliver. In case of an order instrument where you are indicating that it has to be to Mallikarjun, then what you do is you will transfer it by saying that pay, what is it, Prasanna Rani, you will write, and Mallikarjun will put his signature, and so it will be payable to Prasanna Rani instead of Mallikarjun. So here what I have to do, Mallikarjun, I will have to endorse and then give this instrument to someone else. So then Prasanna Rani madam will go and collect this instrument. This is as far as a negotiable instrument, one definition. The second thing is negotiable instrument is a property because it is an entitlement for receiving money. So in that sense, it is a property which is acquired by anyone who takes it bona fide and for value, notwithstanding any defect in title in the person from whom he takes it. So this is a very important aspect of negotiable instruments, which we will subsequently also discuss. That is, if I am using this instrument for payment, again as a consideration and in a bona fide manner, so I will be passing on the person who is receiving it for value and in a bona fide manner will have a better title than the person who is giving it. So maybe I have stolen a check, but this check I am passing for buying a mobile phone. The person who is selling me a mobile phone has made this sale bona fide and he has received that instrument, that check. So he will be having a better title. I don't have a title on the check because I have stolen it. The person who is receiving, because he has taken a bona fide transaction and he has given a mobile phone for value, he will be having a better title. So any defect of the title of the transferor will not affect the title of the transferee in case of a negotiable instrument. Negotiable Instrument Act came into being in 1881. It is also one of the British era acts. So that is the reason why it has stood the test of time. Then it's an act to define and amend the law relating to what are the three named negotiable instruments here. You have promissory notes, bill of exchange, and checks. The act was enacted on 9/12/1881 and it became effective from 1st March 1982. So the three kind of instruments that are referred to as negotiable instruments in the act are promissory note, bill of exchange, and check. The scheme of the act will basically give you what are the various aspects or facets of dealing with negotiable instruments. First, it talks about of notes. It is a preliminary chapter which talks about basic protection of instruments which are in Oriental language and which are used as instruments by custom. Example, your hundis. Hundis are nothing but bill of exchange, but they are written in Oriental language. So most of the transactions, Sharafs and others used to deal with these instruments called hundis, which are basically negotiable instruments in the nature of bills of exchange, which are used for bona fide trade transaction between people by custom. There are various categories of it, so that I will probably just mention subsequently. Then the second thing is talking about of notes, bills, and checks. So here, what is a promissory note, what are the elements, etc., are all discussed. Bill of exchange, check, etc., are all discussed in these sections from 4 to 25. Then parties to notes, bills, and checks. So these are discussed between 26 to 45A. Then negotiation of these instruments is what is the essence for which these instruments are made. So the elements of negotiation and other aspects are dealt with from section 42 to 60. Then once you negotiate, when you want to receive money, you are supposed to present this instrument to the acceptor or drawee or the endorsee. So drawee. So he will have to say that yes, I accept and I will make payment. So that acceptance has to happen, or if he doesn't accept, there will be a dishonor. So these aspects relating to presentment, when it is supposed to be made, how it is supposed to be made, etc., are all contained in section 61 to 77. Then payment is a mechanism which is the reason why negotiable instruments are drawn, issued, negotiated, etc. So in case of delay, what is the interest that is supposed to be paid, etc. Those provisions are between 78 to 81. And discharge from liability on notes, bills, and checks. So the basic mechanism is either if you are transferring for value or you are you are endorsing it, Then finally you are paying it. These are mechanisms by which you are be discharged of the liability. Then if you are not honoring the instrument, then it becomes a dishonor. So a notice of dishonor, what are the provisions relating to that? That is there from 91 to 98. Then of noting and protest, there are certain cases where you will not be in a position to know whether it has been accepted. Suppose the instrument is given where the drawee is someone who is not at all existing in this world. So if you are thinking that he is going to pay you and you are holding the instrument and you are passing it on to that person, it will come back saying that this person is not at all there. And what happens is, it happens by dishonor. It is a case of dishonor. So what you do here is, you go to the notary and you say that this instrument, this fellow is not there. So there is the instrument is not paid. So you get that noted. So this noting and protest provisions are there from 99 to 104. Then of reasonable time. So the time related aspects are dealt with in 105 to 107. Then of acceptance, payment of for honor and reference in case of need. These provisions are there from 108 to 160. So imagine that I am supposed to be getting money from say X, but X is supposed to accept it, but X is not in a position to make the payment. So then there will be Y, who is the brother or the wife, so or say father. So he will say that yes, to protect the honor of X, I will accept this instrument and I will pay. So this is acceptance and payment for honor. So in case I am not satisfied with the protection that is given by him, I can ask that you go and get from say Dhirubhai Ambani. So this kind of reference in case of need also. Those provisions are there from 108 to 160. Then compensation, those provisions relating to compensation are there in section 170. Then special rules of evidence in relation to Negotiable Instruments Act are necessary to enable trade to happen. If these rules of evidence were not there, then probably you would have a lot of litigation. The moment you have a lot of litigation, you are not any better off. So you are back to the same position where you were while you were dealing with contracts. So from that point of view, special rules of evidence are there relating to negotiable instruments. They are dealt with from 118 to 122. Then crossing of checks, this is an important aspect. So these aspects are dealt with from 123 to 131. Then international law in relation to these instruments, these aspects are touched up from 134 to 137. And the most important and the significant section from the purpose of litigation as well as from the purpose of making the payments happen through negotiable instruments, especially checks, is chapter 17, which deals with penalties in case of dishonor of certain checks, precisely for the reason of insufficiency of funds in the account. So what are those aspects where you can file a complaint? What is the procedure for it? All these are discussed from 138 to 148. So this is the coverage as far as the Negotiable Instruments Act is concerned. Then now let us look at a few of the different kinds of instruments, then the rules, etc. So first, the kinds of prerequisites, etc. of these instruments. First, what is a negotiable instrument under the Negotiable Instruments Act? Negotiable instrument means a promissory note, bill of exchange, or check. So it can be only either of these three instruments. They are payable either to order or bearer. Order means to the person or whoever he directs to be receiving the money. Bearer means whoever holds the instrument, he is the bearer. So an instrument can be payable to the order or to the bearer. It is limited in applicability, but it does not affect Indian Paper Currency Act. So these are the notes which were issued. 1 rupee, the notes which were issued by Government of India were under Paper Currency Act. Then Oriental instruments in Oriental language like hundis, etc. So the Negotiable Instruments Act does not, where by custom these instruments are used, Negotiable Instrument Act provisions don't apply. But where there is no custom but these instruments are used, analogous provisions of the Negotiable Instruments Act will apply to these hundis. So these are some of the, this is the definition as far as the Negotiable Instruments Act. First kind of instrument that we see is promissory note. So a promissory note is basically an instrument in writing. So it is not a bank note or a currency note. So I will talk about this bank note or currency note subsequently. Signed by the maker. So it has to be signed by the person who is making the promissory note, and it should contain an unconditional undertaking to pay a certain sum of money. That is, a fixed amount of money to the order of a certain person or to a bearer of the instrument. So it can be to the order, say to Mallikarjun, or it could be to bearer. Then the promissory note expressly payable to bearer. Now, what is a bank note? A bank note is a note which is issued by Reserve Bank of India under the provisions of the Reserve Bank of India Act 1934. If you see the promissory, a bank note, you will find that I promise to pay the bearer a sum of rupees 1000, say, or say 200 rupees, say signed by the Governor Reserve Bank of India, and then on top of it, if guaranteed by the central government. The paper that is there is a promise, and this paper is special. What are the features, what are the form, design, etc.? They are all contained in chapter 3 of the Reserve Bank of India Act. So imagine that this promissory note, a similar kind of a promissory note like a bank note, is issued by any person. Then what will happen? He will become Reserve Bank insofar as issuance of notes is concerned. So according to section 22, Reserve Bank of India is the sole monetary authority. That is, he is the only person, it is the only institution through which notes will be issued or the currency will be put into circulation. So from that point of view, if anyone is issuing any note or a negotiable instrument which is similar to a bank note, then they are acting as Reserve Bank of India. Similarly, if anyone is going to accept these notes as money, then he is acting as if he is taking note from Reserve Bank of India. This is prohibited under section 31. So a demand promissory note payable expressly to the bearer is prohibited. Any bill of exchange, etc., payable to the bearer on demand, they are all prohibited from being issued. And the penalty that is there is the amount of the twice the amount of instrument, according I suppose. This is penalties are provided under chapter 5 of the Reserve Bank of India Act. So the amount of instrument is the penalty that is imposed. So that is the reason. And what is a currency note? A currency note is a note which was issued by government prior to Reserve Bank of India's setting up. The other kind of notes that are there are basically your 1 rupee notes, which are issued by under the signature of the Secretary, Ministry of Finance. But these notes are treated as rupee coins for the purpose of Reserve Bank of India Act. So that's a different story. But a promissory note is excluding the provisions of Negotiable Instruments Act don't extend to bank note and currency note because they are governed by different, the Reserve Bank of India Act and the Paper Currency Ordinance and the previous act, Indian Currency, Paper Currency Act 1861, under which government was issuing notes. So excluding those, any instrument in writing signed by the maker containing an unconditional undertaking to pay a certain sum of money to the order of a certain person or bearer of the instrument. This is a promissory note. So merely saying that I owe you 100 rupees does not make it a promissory note. So this is the structure in which a promissory note is written. That is, place, date, then on demand, I promise to pay Rohit of Delhi, or order a sum of rupees 5,000 rupees for value received. To Rohit, it is delivered, then signed by Rajiv. So here there is a promise to pay, I promise to pay. So who is making it? Rajiv is making it. So he is the maker or the drawer of the instrument. Then who is supposed to be paid? I promise to pay Rohit. So he is the one who is supposed to receive money. So he is the payee. What is the certain sum of money? What is the amount? 5,000 rupees. So it is rupees 5,000 only. So it has to be in words and figures, and where there is a distinction, the words and figures don't match. The Negotiable Instrument Act says that you have to go by the words and not by the figures. So amount of rupees 5,000, and it has to be a stamped instrument. Indian Stamp Act will apply to the promise to the negotiable instruments, and except checks are not stamped, but the bills of exchange promissory note, they are supposed to be stamped in accordance with the provisions of the Indian Stamp Act. Then it has to be signed, only then it becomes valid. Then date and place has to be there because this has a bearing on whether the instrument is an inland instrument or a foreign instrument. Then it is payable on demand. So this is a demand instrument. That is, the moment this instrument is produced, the money has to be paid. Then the instrument could be payable to payee or his order. So Rohit or order. So it is a order instrument. It is not a bearer instrument. That it is not intended to be paid to any individual, whoever is bearing this note, because it cannot be issued. Bearer instrument payable on demand cannot be issued under Section 31 of Reserve Bank of India Act. If you are doing it, then you are violating RBA Act. So now, suppose you are going to indicate the future rate of interest, or you are going to indicate the rate of exchange, because imagine that this is in dollars and you are having a transaction from Indian person and a foreign person, export transaction or something like that. So where you're drawing up and you're indicating that it is $500 exchange rate. So the change in exchange rate, etc., does not make it an uncertain amount. It is a certain amount. Then you are saying that interest is supposed to be paid, let's say 10% or something like that. So that interest recovery, or you had paid a part for the remaining amount. So those kind of amounts are don't make the promissory note an uncertain amount. So it will be treated as certain if you are dealing with, if the issue is relating to interest, if it is in relation to rate of exchange or the balance due, etc. Then the second kind of instrument is a bill of exchange. So bill of exchange is an instrument, but here it is not a promise, but it is an order. This is also in writing, signed by the maker, that is the drawer, containing an unconditional order directing a certain person, okay, to pay a certain sum of money to the order of a certain person or to the bearer of the instrument. So the one who is signing or drawing the instrument is the drawer. So he is the person who is supposed to actually be receiving the, who is supposed to be actually creating this instrument. Then he will direct someone else to make the payment. So the person whom he directs to make the payment is the drawee, and the person to whom the payment has to be made, he is the payee, and this payee could be a person or it could be a bearer. So these, in case of promissory note, there are only two parties. In case of bill of exchange, you have three parties. You have drawer, payee, drawee, and payee. The drawer and payee could be same. Okay, so this is as far as the bill of exchange is concerned. Here you can see that the drawer, Mr. A, his name, address, etc., date of the instrument, then 10,000 rupees. 4 months after date, pay to B, payee a sum of rupees 10,000 for value received to Mr. C. So here there is an order to pay Mr. B. So B is the payee. Then who is giving an order? It is Mr. A. So he is the drawer or the maker of the instrument, and A has to put his signature on the instrument. Then C is the drawee. So C is the person who is being directed to make the payment to A. And so C is the drawee. He is the person who is supposed to make the payment. So in case C is not in a position to make the payment, the obligation to pay will be on A, and the payee will be B. And when is the instrument supposed to be paid? It has to be paid 4 months after date. So here it is not a demand instrument. If I merely show this on the day, I will not be in a position to get the money. So 4 months after April 7, 2015, 4 months later, only I will, the drawee, that is Mr. C, will be obliged to pay. So here again, any future rate of interest or rate of exchange or balance does not make the instrument an uncertain instrument. So here it is payable to B. So though it is written as payable to B, it is treated as an order instrument. You don't have to say pay B or order as it was there in the promissory note. So if it is listed, indicated as B, it means it is to B or order. This is also a provision under the Negotiable Instruments Act. And if nobody is mentioned, it is deemed to be payable to bearer, because he can fill his name and he can get the money in respect of the instrument. So depending upon how you have these instruments, you could have the differences between the promissory note and a bill of exchange. There are only two parties, that is the maker and payee, in case of a promissory note. But in case of bill of exchange, there are three parties, that is drawer, drawee, and payee. Then it cannot be made, a promissory note cannot be made payable to the bearer maker. But in case of a bill of exchange, the drawer and the payee can be the same person. That is like you have a check. So I will say you pay self. So that is possible because a check is nothing but a bill of exchange where the drawee is a banker. That is the difference. So in case of a promissory note, you have an unconditional promise. In case of a bill of exchange, you have an unconditional order. In case of a promissory note, it doesn't require acceptance because the party who is going to have the instrument, he is the person who is there, and who is making the instrument is the one who is agreeing to pay. But in case of a bill of exchange, you need acceptance because you are directing someone else, a third party, to make the payment, and he has to accept the instrument. If he is accepting, then he will make the payment in accordance with the terms. That is why acceptance is important in case of a bill of exchange. There is no question of a conditional acceptance. It has to be in case of a bill of exchange, it has to be accepted, and it can be accepted conditionally also. The maker stands in immediate relationship with the payee in case of a promissory note, but here there is no direct relationship between the payee and the maker or drawer of an acceptance bill stands in immediate relation. The maker or drawer of an accepted bill stands in immediate relationship with the accept. So basically, the person who is accepting and the payee will have the relationship, but the drawer's relationship ends the moment he is directing someone else to accept the instrument and make the payment. So the role of the drawer or a maker ends the moment he hands over the instrument. From then on, the responsibility of getting the money will be on the payee to get it from the drawee. And in case he is not able to pay, it is only then that the maker will become liable. Okay. Then the liability of the maker is primary and absolute in case of a promissory note. But in case of a bill of exchange, the liability is primarily on the drawee. And in case he doesn't make the payment, the liability will be on the maker or the drawer. So in that way, his is a secondary liability, and it is conditional upon the drawee not accepting or making the payment. If it is dishonored, then no notice of honor is required. Notice of dishonor is required in case of a promissory note. In case of a bill of exchange, a notice of dishonor is necessary. If it is dishonor, it is not required to be protested. So similarly, where there is no notice of dishonor, there is no question of protest in case of a promissory note. But in case of a bill of exchange, there is a notice of dishonor and there has to be a protest for dishonor. Then it cannot be, a bill of exchange can be drawn in sets, whereas a promissory note cannot be drawn in sets. What is a bill of exchange drawn in sets? Imagine that I have a transaction with generally these bills are drawn in sets with where there are foreign parties who are involved. So I will have this bill drawn up in set, maybe 2 or 3 sets, and I am indicating that this is bill 1. All these 3 are instruments which are parts, and the obligation is similar. That is, I have to pay X. So I direct X to pay money to Y. But why am I drawing it in 3 sets? I am drawing it in 3 sets because one, I will send it through post. The second, I will send it by through a person who is traveling. The third, I am sending by courier. So whichever I am able to receive, whichever I am able to reach the other person, to that extent, the speed of transaction will be there. Or if imagine that the post, it is something is lost in transit, then you will not be in a position to get the benefit. So to enable dealing with the complications of sending across the instruments across through different modes, so that some or the other way he will receive it. It is just like I am going to have a pass, I am going to take a ticket. So if my pass is lost, then I have a ticket. So that is the logic that is there in bills of sets. And in this, to the other person to know if one of these bill is paid, then all the parts will be deemed to be paid. So I will have to indicate specifically this is part 1 of the bill. This is second part of bill, and only if the other part is not paid will the obligations be there to pay. So this way, bill of exchange can be drawn in parts, whereas a promissory note cannot be drawn in sets. In case of a promissory note, there cannot be a conditional acceptance. In case of bill of exchange, there can be a conditional acceptance. So these are the distinctions between the bill of exchange and promissory note. And we saw about the promissory note and bill of exchange. It could be a bearer instrument, it could be an order instrument. An order instrument means pay Mallikarjun or order. So it becomes an order instrument, or merely saying pay Mallikarjun. It will also be treated as pay Mallikarjun or order, and it becomes an order instrument. In this kind of an instrument, for me to transfer this instrument to someone else, the process of transfer is called negotiation. And what is this transfer? I am doing it so that I want the person who is receiving it to be owner of the property of this instrument. So if I want to transfer to any person to constitute the person to be a holder, then what am I doing? I am negotiating the instrument according to section 14. And if it is a order instrument, merely transferring it will not be enough, because the instrument says it has to be paid to Mallikarjun. So what I have to do, I have to say pay to say X, and I will put my signature and then hand over the instrument to X, in which case only it will be payable to X. So what am I doing for transfer? Negotiation. I am endorsing it, putting my name across and signing with an order to pay is what is called endorsement. There are different types of endorsements which I will subsequently deal with. So this endorsement I have to do, and merely endorsing does not make X get the money. So I will have to transfer, give him the instrument also. So an order instrument is transferable, negotiable by endorsement and delivery. Only if I am doing that, X will have all the rights in respect of that instrument as a holder. The second case is, imagine that I will say pay bearer rupees 1000, or I will say pay dash rupees 1000. So either of these cases, it becomes a bearer instrument, and whoever holds this instrument can go and get the money. So this, how can you transfer this instrument? By merely delivering it. You will be in a position to transfer the property to the person who is holding it. So this way, endorsement and delivery is required for an order instrument. Mere delivery is enough in case of a bearer instrument. An order instrument also can be transferred, it can be converted into a bearer instrument. How do you do it? I am, say, Mallikarjun, pay Mallikarjun, or order is there. Then Mallikarjun, what it does, pay dash. I will give a blank endorsement and put my signature across and give the instrument. So this order instrument in favor of Mallikarjun or order has now become a bearer instrument because the endorsement is blank. The other person can sign it, or merely he can pass it on to someone else. And finally, whoever is receiving the money, he can put his name and then give the instrument to get the money. So this is as far as negotiation, endorsement and delivery and delivery. So these are the methods which are there. Then what is check? Check is basically nothing but a bill of exchange. So here also you will have three parties: a maker of the check, or the drawer, then a drawee, and in case the drawee will be only a specified banker. And then this check is a demand instrument. So it has to be payable expressly, not expressly payable otherwise than on demand. So it is a payable only on demand. There cannot be a time check. So it is antithetic to the concept of check, because I want to give money. Instead of giving my money, I am asking the person to go to my bank and get money. So it has to be a demand instrument only. So it is similar to a bill of exchange. But in case of a check, the note stamps are required. So in that way, it is a different instrument. It is basically to facilitate payment that you have. The check system has evolved. So here, what do you have in case of a check? This is a check. So this is a check of Mallikarjun. So Mallikarjun is the maker or drawer. And who am I authorizing to make the payment? I am authorizing ICICI Bank because it is that branch where I have my account, that bank where I have my account. So the drawee is ICICI Bank. And to whom am I paying the money? I am directing ICICI Bank, ordering the ICICI Bank to pay Siva or bearer. So what I can do is I can strike off or bearer in which case it becomes an order instrument. Or it could be Siva or bearer, in which case Siva can hand it over, put his signature across and say, pass it on. So any bearer of the instrument can receive the instrument. So in this way, it is signed, it is dated, and it is payable on demand and payable to the payee or bearer. So this is as far as a check is concerned. So what is the difference between check and a bill of exchange? So a check is always drawn on a bank. So it may be drawn on anyone, including a banker. A bill of exchange can be drawn on anyone. Then a check is always payable on demand. A bill of exchange can be payable on demand or payable after a particular period of time or on site. Then it is always drawn on a printed form. The check is a very specified document because it has to be in a particular form, and that form is sacrosanct. And because the machine processing and other things are happening, now you have check truncation system through which these instruments are sorted, processed, etc. So for that particular reason, you need to have a particular printed format of check, and only those kind of instruments can be issued. In case of a bill of exchange, it is not necessary to have a particular format of the instrument. Then the drawee or banker need not accept the check. So in case of a bill of exchange, acceptance is an important part for making payment. But in case of a check, there is no need for acceptance because it is understood that I am directing a banker and he is obliged to pay. He cannot say that I am not refused, I can't accept this check. There are certain reasons where he can say that I won't be in a position to pay the check, but that's a different story. But if it is a genuine person who is putting his signature across and there are no corrections, mistakes, etc. in the instrument, in writing of the instrument, then the person, the bank is bound to pay. He cannot, the dishonor by non-acceptance cannot happen in case of a check. Then the drawee need not accept a check. Then accordingly, there is no privity of contract between the payer and the check. It is always supposed to be drawn against the funds in the hands of the banker. So ideally, you need to give, ideally, you have to give an instrument which is of an amount where you have sufficient balance in your account. In case of a bill of exchange, it is not supposed that you are going to have your balance in your in the drawee's account. But in case of this, sufficient amount only if it is there in your account, you will be issuing, you are supposed to be issuing a check. Otherwise, you will be put through the legal process of section 138, etc. Then the liability, there is, this one is instrument. Once it is drawn, it is valid. The validity period of the check is just 3 months. In case of a bill of exchange, the validity could be different depending upon the kind of the tenure that you set. Then in case of check, you don't have a stamp duty. In case of a bill of exchange, you have a stamp duty. And a bill of exchange can be drawn up in sets. A check cannot be drawn in sets. Ideally, for ensuring safety, you can cross the check. The crossing could be of three different types. One is called a general crossing, where you are putting two cross lines across the instrument and you are writing and co, or the mere crossing, that is general crossing. So in that particular case, the bank is obliged to put the money into an account only. You could indicate account pay also, pay into the account. So these kinds of crossings are general crossings. The other kinds of crossings could be, you will say pay. You will cross and you will write State Bank of India. That is, it is a special crossing. That is, you are asking that amount to be paid into the account, but you are asking that amount to be paid into the account of State Bank of India. Okay. So this is special crossing. Then the other kind of crossing is something where you are crossing and you are saying not negotiable. But if you are writing not negotiable, that doesn't make the instrument not a negotiable instrument. The instrument can still be transferred by endorsement and delivery. But the only thing that will be there is that the holder of the subsequent holder of the check will not have a better title than the person who is originally who has transferred the check. So this is another element, important element of a Negotiable Instrument Act. By writing not negotiable, you are taking away that factor that a holder in due course will have a better title than the transferor. That negotiable instruments character you are doing away by crossing, by writing not negotiable. And similarly, when you are having a what is it, special crossing of say State Bank of Mysore, if this institution has an arrangement of clearing with another bank, then it can again endorse and say that pay to say ICICI Bank. But the requirement here is that bank may not be a participant in the clearing house, in which case the clearing house participant in his favor, he can again cross. Otherwise, the amount has to be paid into the account of that particular bank. These are some of the aspects. So this is as far as crossing, general crossing and special crossing is concerned. So other than with the check truncation system coming in now, there are no alterations in a check are permitted. The only alteration that can be done is in the date and in striking of the bearer. Otherwise, no other alteration in terms of amount, etc., can be made. And the instrument has to be clearly of the pattern that is specified by Reserve Bank of India, the standards that are specified by Reserve Bank of India. Those instruments have to be there. The processing of these instruments is taking place through an institution called the clearing house. Earlier, physical instruments were moved. Now you have a mechanism where a check includes an electronic check or a truncated check. When you say an electronic check, it is not having a physical instrument, but the instrument is also an electronic instrument. And the signature that you are making on that is also a digital signature. If an instrument of that nature is there, where you are authorizing the bank to debit your account for paying to a person, and the signature is digital and the instrument is digital, then that kind of a check is called as an electronic check. The other kind of check is what you generally use, if that is you have a physical check, you are signing and writing and other things, and you are handing it over to a person. That person puts it in his bank, and from then on, at some stage, the image of the check is captured, and that image moves from there on, whereas the instrument is kept. That kind of a check is what is called as a truncated check. What you have in our system presently is the check truncation system, where the image travels for the clearing process. If you say I am Mallikarjun, I have issued this check to say Siva. So Siva is the payee. So he will receive this instrument, and what he will do, he has an account with HDFC Bank, Lakdi Kapul. So he will tender this instrument in HDFC Bank, Lakdi Kapul. So at HDFC Bank, Lakdi Kapul, the image of this check will be captured, and the check will be retained with Lakdi Kapul, unless the other ICICI Bank wants to have a physical check of the instrument. Otherwise, the check will be with HDFC Bank and it will go into its storage. ICICI Bank will see the check based on the image which has been captured by HDFC Bank and it has been transmitted. And the image is what will be used for clearing process. And this is what is called check truncation. So this check truncation is a new aspect that has come about. Traditionally, you had only checks. When the IT Act came into being, amendments were made to the Negotiable Instruments Act, also for providing for electronic checks and check truncation. Okay. So now, what is the classification of instruments? You could have different kinds of instruments. First classification is bearer or order. So a person who is holding the instrument is the bearer. An instrument could be a bearer instrument or it could be an order instrument. If it is written to some in favor of some person, pay some person or his order, then it becomes a bearer, an order instrument. If no person is indicated, or if it is pay to bearer is indicated, it's a bearer instrument. And depending upon when it is payable, an instrument could be payable on demand. That is, the moment he is presenting that instrument, it has to be paid. That is a payable on demand. The other kind of instrument is what is called as a time instrument or on after sight. That is, I have to present that instrument and afterwards I will be getting the money, not immediately on presentment. This kind of instruments. Basically, you say after 4 months after date or 2 days after sight, or those kind of instruments where it is not immediately payable, they are called payable on demand or sight. Then, depending upon where it is drawn and to whom it is payable, it will be treated as an inland instrument or a foreign instrument. If an instrument is made or drawn in India, are payable in India or drawn on a person resident in India, then it is an inland bill. If any of these requirements are not met, then it is a foreign bill. That is, if the bill is drawn or made outside India, then it is a foreign bill. Or if it is payable outside India or drawn on a person not resident in India, then also it will be a foreign bill. So now we have seen all these aspects. So what are the essential characters of negotiable instruments? First, it represents property. That is, it entitles the holder of the instrument to certain amount of money. It is easily transferable. That is, if it is a bearer instrument, mere delivery is enough. If it is an order instrument, the endorsement and delivery is sufficient to transfer it from one person to another. And the title, as I told you, a holder in due course, that is someone who receives this instrument for consideration in a bona fide manner within the maturity, during the maturity, during the tenure of the instrument, it has not become mature, and who has received this instrument bona fide, that person will have a better title than the person from whom he has received this instrument. So a transferee gets a better title than the transferor, subject to fulfillment of certain conditions. Then the right to sue. The payer or holder in due course can sue in his own name in case of dishonor, independent of others' title, because he is holding this instrument, or his title of the instrument is independent of the previous persons. He has the right to sue. Then prompt payment is facilitated through the negotiable instruments, and that is the reason why they are extensively used. That is, they can be payable on demand or they can be payable on or after a specified date or time. So in that way, certainty of there, and if you are not paying, then there are consequences to it, which will make this even more strong in terms of enabling payment for trade transactions. Then salient features of negotiable instruments. This is a very important area. These are instruments in writing, common for all negotiable instruments. That is, there is an unconditional promise or order to pay. Then they are payable to a person or his order or to a bearer. Then clear and specified period of payment is provided for to make it very clear when the amount is due and when it is supposed to be paid, when it becomes payable. Okay. Then it must be for money only and the sum must be certain. The exceptions are not exceptions basically, but it will be treated as certain if it is dealing with foreign exchange rate, if it has interest rate, or if it has balance amount of money that is paid. All these cases, it will be treated to be certain sum of money only. It must be signed by the maker or drawer, and in case it is negotiated, the endorser is supposed to put his signature. Only then it will be a valid instrument. Then it can be transferred several times before maturity till maturity. That is, there is no limit on how many times you can negotiate or transfer an instrument from one person to another. You can travel n number of times till the maturity. It can keep changing hands from one person to another. Okay, it is easily transferable. That is, if it is a bearer instrument, merely delivery is enough. If it is an order instrument, endorsement and delivery is enough for transfer. You don't have to have a transfer deed and all the formalities that are there. In case of assignment of contracts or other kind of that cumbrous nature of transfers is not there in negotiable instruments act. In negotiable instruments, they are easily deliverable. Then a bona fide transferee for value acquires an absolute and good title to the instrument, even if the transferor had a defective title. So these are if he becomes a holder in due course, he will have a better title than the previous person. Then a holder in due course can sue on the instrument in his own name. The concept that is there, the maxim is domino martis causa, that is, most complete right of ownership or absolute ownership will come due to marketing. It applies to negotiable instruments. So what is the opposite principle that is there in transfer of property is nemo dat quid non habet. So that is, nobody gives more than what nobody gives what he has not. So I will be in a position to pass title only to the extent of the title that I have. But in case of a negotiable instrument, this principle does not apply. So I will be in a position to transfer a better title to the transferee if I am doing it for consideration, etc. So the transferee gets better title than the transferor. Then it is presumed that the instrument was drawn for consideration and it was accepted or negotiated for consideration. So these are some presumptions that are there. Negotiation we have already seen. Then negotiation is by endorsement and delivery in case of an order instrument. So what is endorsement and what are the types of endorsement? We'll just have a look at. First, endorsement. Say it's titled INDOR, INDOR, and it can be written as ENDORFC also. You will find both in the Act. You will find endorsement. Generally, you will find endorsement. Then, maker or holder of a negotiable instrument signs the negotiable instrument otherwise than as a maker for the purpose of negotiation. That is to transfer the property to the holder. On the back or on the face of the negotiable instrument or on a slip annexed to the negotiable instrument, or signs a stamped paper for this purpose. So the transfer endorsement should be by the maker or holder of an instrument, signs on the negotiable instruments otherwise as a maker. So if he is merely signing it as a maker, then he is making the instrument. But here he should be signing it across the holder signing for the purpose of negotiation, that is for the purpose of transfer of ownership and keep the holder as the owner of the property. Then the endorsement could be on the back of the negotiable instrument, on the face of the negotiable instrument, or if you can't do it on either places, you could have a slip. This is what is called as an allonge, ALLONGE, okay, or a slip of paper annexed to the negotiable instrument, or signs a stamped paper for this purpose. So all these mechanisms could be mechanisms of endorsements. So the one who is making the endorsement is the endorser. The other party who is receiving this endorsed instrument is what is called as an endorsee. So basically, the person who is moving this instrument is an endorser. The person who is receiving this instrument is an endorsee. And now this endorsee will become a holder or a holder in due course, depending upon the conditions that are there. The endorsement could be in blank or in full. That is, if I am going to say pay dash and put my signature across, it is an endorsement in blank. Or I will write the whole name and a direction and then put my signature. Then it will be a endorsement in full. The endorser signs his name only, and the person to whom it is endorsed, if it is left blank, it is a blank endorsement. If it is signed and if it is given to the person signs and it is writes a direction to pay the amount to a specified person or his order, then it becomes a full endorsement. So in case of a endorsement in blank, it can be treated as if it is a bearer instrument and it can be transferred. An endorsement in full makes it an order instrument. It has to be negotiated accordingly. The other types of endorsements are conditional endorsement. That is, pay if Mallikarjun gets married. So this is, or Mallikarjun dies. So if it is a certain thing or an uncertain thing, here it is not necessary that it has to be a certain condition that needs to be met. So if it is, you can make it conditional by adding a particular pay if he is supposed to be, if he is coming and taking this money from Bombay. So these kind of conditions can be specified. So it excludes this liability or makes it conditional on happening of an event. So if something happens, yes, if that event contingency condition is not fulfilled, then there is no obligation to pay. A restrictive endorsement is something where you are restricting it to be made to that person only. So the right to negotiate or receive amount you are restricting by saying to pay to X only. So it cannot be paid to anyone other than X. So this is as far as section 50 is concerned. Then there is some other thing called sans recourse. So whenever you are endorsing something, if the other person is not getting it, you will be liable. So what you are doing here through sans recourse endorsement is you are taking away the recourse to the person who is making the endorsement. So endorser is excluding his liability by saying endorse pay Y sans recourse or Y without recourse to me. So the other kind of endorsement is where a notice of dishonor can be waived. So in those cases, it is called as a facultative endorsement. So the endorser waives the right of endorser to give notice of dishonor because he is the one who will be anyhow having knowledge, so he will be in a position to make the payment. So for him, it is not necessary that he should be given a notice of dishonor. He will get to know about it, so he is waiving this notice of dishonor. Then the other cases, expenses without expenses pay by. So here the endorser clearly states that no one should incur any expenses on his account in respect of the instrument. So these are the various kinds of endorsements. What are the legal consequences of these endorsements? First, transfer of right, interest, property, or title in the instrument is made from the endorser to the endorsee. Then the moment it is transferred to the endorsee, the right to further negotiate is also transferred, except in case of restrictive endorsements. Then endorser certifies to endorsee the genuineness of the instrument and genuineness of all the prior endorsements. So when I am saying that I have received this and I am passing it on, I am agreeing that the previous person from whom I have received it, his title is there and all the previous person's endorsements, I am saying that they are genuine. Only then I have received it and now I am passing it on to you. So this is a certification that of the genuineness of the instrument and genuineness of all prior endorsements. Then the endorser guarantees to endorsee that he had a good title to the instrument. So this is a presumption that is there, that he had good title and hence he is passing it on to you. Then the endorser undertakes to compensate every subsequent holder of instrument in case of dishonor or non-payment of instrument present according to its tenor. So basically, principal debtor endorser is the principal debtor to the endorsee. Okay, so if the endorsee does not get the money, he will have to take it from the endorser. But subsequently, the endorsee transfers it to someone else. So the obligation will pass to the person who has endorsed it, and this person will now become the secondary liability. That is, he will become a surety. So an endorser undertakes to become a principal debtor in case of the endorsee and surety for payment to all the subsequent endorsees. These are the legal consequences. So how can a valid endorsement be made? It is made by a maker or holder on the instrument or on a separate slip, and it is better if it is made with ink because it will not be in a position to be modified. Then it must contain an order to pay. So without an order to pay, it doesn't become an endorsement at all. It has to be signed by the endorsee or by hand or thumb impression. So the bibelot is not something. This by an uneducated person who cannot sign, it has to be by his hand impression or left hand thumb impression. Sorry, by left hand thumb impression. There is a mistake there. Then it is completed by delivery. So an endorsement, mere endorsement and holding that instrument will not negotiate. The instrument will not be negotiated. Only when it is followed by delivery will the title be passed. And if there are a series of endorsements, the order in which the endorsements are appearing, it will be deemed to be that the endorsements have been made in that order. So once you are presenting the instrument, so now the first thing is you are making the instrument. Then subsequently you are transferring it from one person to another by either endorsement and delivery or delivery. Then the other person, you are making the presentment of the bill and to the drawee. So what does the drawee do? He will say that yes, I accept that I will make the payment to the payee. So this acceptance, what are the essential elements that are there? The acceptance has to be in writing, and he need not specifically say that I have accepted. But if he is merely putting his signature, that is enough indicating his acceptance of the drawee to make the payment or the endorsee to make the payment. Then acceptance should be on the bill, either the front or back. So acceptance cannot be on a separate slip or an additional paper as in case of an endorsement. It is valid only when delivered. That is, I am saying accepted and I will have to give it back. Only then it will be valid. Then the kinds of acceptance are general acceptance is a valid acceptance. Then qualified if condition is applied, then it becomes a voidable acceptance. If I am going to indicate that I will pay you, I will have a receive an instrument saying that I have to pay Siva. So I will receive the instrument and I will say I will put my signature across. Then it is a general acceptance. So it is as good as accepted. But I am going to say that I will, what is it accepted if you receive the money at Mumbai. So then what am I doing? I am making it conditional. So now if Siva says that I am okay with it, then it becomes a valid acceptance. But if he says that no, I am not going to come to Mumbai, then it will become an invalid acceptance. So it is valid or void at the instance of the payee. If valid, if it will become valid if the payee accepts. If he doesn't, it becomes invalid. So what are the presumptions or special rules of evidence about Negotiable Instruments Act? This is dealt with in the chapter 12 of the Negotiable Instruments Act. So first, section 118 talks about the presumptions. Then there are certain aspects relating to estoppel, etc. So there, that will deal subsequently. The first thing is consideration. So the making of a promissory of a negotiable instrument or drawal of a negotiable instrument, then acceptance of the instrument, endorsement, negotiation, transfer, all these, the consideration for these transactions is always presumed. You cannot say that it is done for free. Then date. If it is dated, it is indicated, it is presumed that the instrument was made on the day that is appearing on the instrument. Then time of acceptance. So it is generally presumed that acceptance is within reasonable time after its date and before maturity. Then the time of transfer, if it is not indicated, it is presumed that all these transfers happened before maturity. Then the order of instruments, as I told you, if there are several endorsements, the order will be deemed to be the order in which they appear on the instrument. Then in case of a loss promissory note, it is presumed that it would have been stamped and adequately stamped, not merely stamped. So in case of instruments, you have a category of instrument called inchoate instruments, in which case generally what you have is, suppose 5,000 rupees is there, you are supposed to put in a stamp duty. The existing stamp duty is at 50 rupees. So imagine that you are having an instrument where the amount is not written, but a 50 rupee stamp is paid. So the amount is not there, so it becomes a inchoate instrument. So it is the liability in this particular instrument is, if 50 rupees stamp duty is applicable for about 5,000 rupees value, then that will be the value for which this instrument can be honored. So if it is beyond that, no, inadequately stamped instruments, etc. So, but if imagine that the instrument itself is lost, then you can't verify whether it has been adequately stamped or not. So that is where the presumption comes into play, saying that the instrument is, it is presumed that the instrument was duly stamped. Then a holder of an instrument is presumed to be a holder in due course, except in case a negotiable instrument has been obtained from lawful custody by any offense, fraud, or for unlawful consideration. In these cases only, it cannot be presumed that he is a holder in due course. But otherwise, a holder will be presumed to be a holder in due course. The burden of proving that he is a holder is a holder in due course in cases where it has not been obtained. In those cases, like where there has been an offense that has been committed or where there is a fraud, in those cases, the holder in due course has to prove that he is holder in due course. Then A fact of dishonor. So on producing proof of protest in a suit, the fact of dishonor is presumed. You will go for a suit and you will protest only when there is a dishonor. So this will be presumed while you are dealing with it. Estoppel against denying that. So estoppel is that you cannot go back on your word. In a suit on a negotiable instrument by a holder in due course, maker of a promissory note, drawer, acceptor of a bill of exchange, check, or acceptor of a bill of exchange for honor, they are not permitted to deny the validity of the original instrument made or drawn. So they are stopped from denying the validity of the original instrument. So he has made the instrument and he has signed it, and if subsequently a holder in due course comes, he cannot go back and say that no, I didn't. The original instrument is not valid. It is not made by me. It is not drawn by me. Those kind of defenses are not valid. So they are stopped from making this. This is according to section 120. Then a maker of a promissory note or an acceptor of bill of exchange payable to order is not permitted to deny the payee's capacity at the end of the note, at the date of the note or bill, to endorse the negotiable instrument. So if the payee is there, then he will be having the freedom to endorse it to anyone. So if tomorrow there is a suit by a holder in due course, he cannot say that the other fellow to whom he was supposed to be making the payment, he doesn't have authority to endorse the instrument. So that cannot be made. So a maker or an acceptor of bill of exchange payable to order cannot deny the payee's capacity at the date of the note or bill to endorse a negotiable instrument. Then, in a suit on negotiable instrument by a subsequent holder, an endorsee of a negotiable instrument is not permitted to deny the signature or capacity to contract of any prior party to the negotiable instrument. So we said the presumption. Here we have talked about what is it? The legal consequences of endorsement. So here we say an endorser guarantees to endorsee that he has got a good title to the instrument. Then he cannot say here endorser certifies to the endorsee that of the genuineness of the instrument and genuineness of all the prior endorsements. So that is what is indicated here in terms of an estoppel. So an endorser of a negotiable instrument in a case filed by a subsequent holder, he cannot say that the previous party or does not have the capacity. So the issue is, if he didn't have, then why did you endorse in the first place? Okay. So this is estoppel that is there. So these are some of the aspects. So we will stop this session up to this point. So we have talked about negotiable instruments, promissory note, bill of exchange, and check. We've talked about the features of these instruments, the differences between the promissory note and bill of exchange and check. Then we have talked about the salient features of the negotiable instruments. Then we have talked about different kinds of what is negotiation. We have talked about endorsement and delivery and endorsement. We have talked about different kinds of endorsement, that is blank endorsement, endorsement in full. Then other kinds of endorsement like restrictive endorsement, facultative endorsement, endorsement sans recourse, endorsement sans phrase, that is without payment, then conditional endorsement. So these are the various kinds of endorsements. Then we've talked about acceptance. What are the essentials of a valid acceptance we've talked about, and then what are the general presumptions relating to relating to negotiable instruments. So in the next session, we'll talk about certain other aspects relating to this relating to negotiable instruments. We'll talk about the dishonor of check, etc. Okay.